Paul Harrell, weekdays from 4 to 6. Learn more at paulharrell.com.
We told you last hour about a bunch of new laws that go into effect today. It's made some mainstream publications. We're going to tell you now about another law that has not made mainstream mainstream publications as much. Here to talk about it, we have from Greer's Ferry, Mr. Jim Ennis joins us on the line. Jim, welcome to the Paul Harrell program, sir.
Thank you, Paul. Appreciate you having me here.
So I'm really glad that you could come on. This bill, which is now Act 486, was House Bill 1362 concerning the rights of a concealed handgun licensee. So I was wondering, what if you can just tell us a little bit, in your opinion, what does this bill do?
Well, what this bill does is it basically changes the assumption that the concealed carry handgun license granted by the state of Arkansas State Police, it changes that assumption of that it's granting a privilege by placing within the CHCL code that the Arkansas State Police have to follow. It acknowledgement that that right exists outside of the concealed carry permit program, if that makes sense.
Yeah, it does. Matter of fact, okay. You look at the lead sponsor, this state representative John Payton, and I get the feeling, and I know this is true. This was in a direct response to, and I love it when that happens, to a situation that occurred. I guess a couple of years ago. I want to read this first, though. This is a direct quote from the bill. A license to carry a concealed handgun issued under this subchapter shall not be denied, suspended, or revoked because a person was lawfully executing his or her rights to carry a firearm under the United States Constitution, Amendment 2, the Arkansas Constitution, or the Arkansas Code. Now, when the Arkansas Code is thrown in there, Jim, that's really referring to 746. Is that correct, Act 746?
It is. And probably we could step back and say that 486 came about in large part as a result of the two very poorly written Attorney General opinions regarding Act 746. In Attorney General Leslie Rutledge's opinion, she stated that in general, merely possessing a handgun on your person or in your vehicle does not violate Code 573-120 and may be done so if it does not violate other laws or regulations. But she put in 4 critical caveats in her opinion. First one was that law officers can freely question anyone carrying a weapon about their purpose for carrying a weapon, concealed or open. Other statutes prohibit open carry in certain circumstances, such as the state capitol, for example. Number 3 was the private property owners are entitled to keep firearms off their property. So stores that have the sign out front saying no firearms allowed, that was part of it. But the 4th caveat was probably the one that really messed everything up. And that one was 746 does not affect concealed carry statutes. Mm-hmm. All carrying concealed weapons still must comply with permitting and other requirements. So a person who does not have a concealed carry permit is allowed to open carry freely in the state of Arkansas. But someone who has a concealed carry permit issued by the state of Arkansas, and that person has gone through all the FBI background checks, done the training and so forth, because of the way her opinion was, they still could not do that because the CHCL statutes that govern CHCL would not allow someone that has a CHCL permit to openly carry.
Yeah.
So so she automatically divided people into two groups.
No
Those
doubt.
who could.
And I remember that opinion. I remember that opinion. It was, to me, it was just kind of hit and miss. I appreciated the fact that, a large, the Second Amendment crowd, me included, we weren't crazy, when we were fighting local law enforcement officials that were just ignoring the plain text of, Act 746 and how it decriminalized the possession of a firearm. But then there at the end, that last part about the Arkansas State, that was a bailout for the Arkansas State Police that I think gets tons of money from people getting their concealed carry license. It's essentially a tax to be able to exercise your right, as well as the renewal fees that come in. That was a big part of this as well. And it just didn't make any sense that you could, if you had a concealed carry license, they could now, just because they disagree with the policy of Act 746, that is the law, they could now tweak their rules of, if you do open carry, we'll take your concealed carry license away. There were even people, and correct me if I'm wrong, Jim, there were even people that said, okay, Arkansas State Police, if you're going to take away my concealed carry because I open carry, thereby taking away my reciprocity in other states, some people were going to other states and getting permitted in other states, so the Arkansas State Police couldn't take it away, still had to honor it, and they could still open carry. Did that actually happen?
It did. I have heard, and I don't have anything in front of me saying otherwise, but I have heard that the Arkansas State Police, in retaliating against that, was saying that, okay, if you say, let's say you have an Arizona concealed carry permit.
That was where everybody was going, I thought, because Arizona allows you.
It was.
Yeah.
Yep. And you could get one through Arizona, but what Arkansas was saying was if you hold a Arkansas state driver's license and you are a permanent resident of Arkansas, you only have 90 days in which you have to switch back over to an Arkansas state permit.
Okay. All right. So they were trying to.
So
Okay.
see, they were exactly.
Mm-hmm. Yeah.
They were trying to make it. And Leslie Rutledge's opinion, that last part that I read to you about the concealed carry permit part of it, that was solely there to protect the $4 million a year that the Arkansas State Police collect on average for new permit holders and those who are renewed.
And is that $4 million? You don't have to answer this if you don't want to, but I'd love for you to. Is that $4 million maybe why this new law that goes into effect today did not get signed by Governor Asa Hutchinson? He just simply allowed it to become law because the second section, Section B of this new law, it's a very short bill, says the Department of Arkansas State Police shall not promulgate any rule and shall amend any existing rule that would result in a licensee having his or her license to carry a concealed handgun suspended or revoked solely because he or she possessed a handgun and the possession was not in violation of any criminal offense. What are your thoughts on all that?
Well, I think you're correct, and I think, and again, I'm you could correct me if I'm wrong, but I think that Act 486 was the only bill that passed through the legislature this session that was not signed by the governor. That passed in.
Well,
I don't think he let anything else sit on his desk and pass on except for this one.
There was at least one more, and it was a controversial bill.
Okay.
It was a non-controversial bill, but he thought it was. American Law and American Courts by State Representative Brant Smith. All the controversy about, hey, we don't need Sharia law in Arkansas. And then, of course, just was allowed to become law. But to your point, it doesn't happen very often, but this was he was kind of in a similar circumstance to where, popular opinion, it's one bill was about the Bill of Rights, and this was about a specific Bill of Rights, the Second Amendment. So,
exactly.
It's pretty fascinating stuff here. So tell me, we're talking with Jim Ennis. He's called in from Greers Ferry. This new bill that, thanks to John Payton and others, House Bill 1362 is now Act 486. It's in a direct response to the Arkansas State Police essentially now trying to protect that revenue by changing the rules of a concealed carry license to prevent people from open carrying without a permit, constitutional carry under Act 746 in the state of Arkansas. Tell us about, is it Tanner? Is it Drew Tanner?
Drew Tanner, he was back in November of 2014. Now, this was prior to Leslie Rutledge's opinion on 746.
Okay, so but we were under the really well educated Dustin McDaniel's opinion that just ignored the entire law in its entirety.
Pretty much.
Okay, go ahead. Sorry, continue.
He pulled out 2 words out of 746, the vehicle, and said that it would only pertain to the vehicle. But anyway, but in November of 2014, Drew Tanner basically he was at the Searcy Walmart Supercenter. He was open carrying, and he was approached by at that time was a stranger. He did not know who this gentleman was, and basically this gentleman came up and grabbed Drew Tanner's right arm, and this is all on video.
I saw the video.
From, from the Walmart. Their security cameras caught the vast majority of this, and they had not an altercation, but the gentleman or the guy basically grabbed Drew Tanner's right arm and did not let go of it, and asked him, basically, are you a law enforcement officer? Where is your badge? And really got into Drew's face about the fact that he was open carrying. And during this time, the gentleman never did offer any, did not let him know who he was, did not identify himself for several minutes. And finally, after Drew got on the phone and called 911, called the Searcy Police Department, only at that time did this gentleman basically identify himself as an off-duty state trooper.
Okay. So, because I've seen that part, and there's a website, Cop Block, and I'm not entirely familiar with them, but I mean, they have this one story: off-duty Arkansas state trooper accosts man legally open carrying, has him arrested after a complaint is filed. So he's just minding his own business at Walmart, and I actually, you see the security camera, and you can tell that the off-duty state trooper's statement, his official statement, completely contradicts the video of their first encounter, and he does just accost them. And it was just kind of this showing this this uncomfortableness that law enforcement had when Act 746 was first being realized. But something happened after that, right? A week or two went by. This man, Drew Tanner, ended up in a vast amount of legal trouble because it looks like in the next incident, the state trooper came back to that Walmart after following him there in uniform and arrested him. And what else happened?
Well, 4 days later, after the first event, after the first part of this happened, 4 days later, Drew Tanner, after he had called Walmart corporate offices, got their official opinion on open carry, which was, we don't have an issue with it if it abides by state law. Okay,
right.
So Drew had made he had called the store manager there in Searcy and set up, an appointment to discuss the store policy so that this wouldn't happen again. And he went this time without his weapon, and you can see on that surveillance tape that it's not 4 minutes after Drew pulls up that the state trooper pulls up. Now, this time he's in full uniform, and basically he puts Drew Tanner in handcuffs right away. I mean, it's within a minute or two of the state trooper approaching Drew Tanner that he puts him in handcuffs and escorts him out of the store, and the Searcy Police Department again releases Drew without any
Incident,
charges being made on that second time. It was only after Drew Tanner filed a complaint with the state police that this trooper.
But the trooper also, right? I mean, after the second encounter, the trooper took his concealed carry license away, and then he files a complaint, and the Arkansas State Police say, "Oh, we've done nothing wrong. He was right to take your concealed carry license," and that's what kind of started this whole problem, right?
Yes, that is correct. And Drew went to court. He lost the first court case, but he did appeal.
Now, hang on a second, Jim. He goes to court though because somebody files charges against him, right?
Yes, the state trooper filed. It's called obstruction of a government operation.
Unbelievable.
That's what he was found guilty of, or charges were filed against him for obstruction of a government operation, which still to this day we have no idea what that means.
So it cost this guy Drew Tanner, cost him thousands of dollars in legal fees. He was found guilty in one court, found not guilty in the higher court on appeal, and that's what this guy was going through, all because he was obeying the law. And so we have now this bill that goes into effect today, House Bill 1362, and it's now essentially saying, hey, Arkansas State Police, if somebody is using Act 746 to carry, you cannot persecute them. You cannot go after them because they also have gone through your program and paid the tax and gotten a little library card saying that they can use their Second Amendment right. You cannot, just because you disagree with open carry and your $4 million in revenue every year that may be subject to loss, doesn't mean you can go and make trouble for these guys and put them in court, right? I mean, that's what this bill's trying to do.
Exactly. It at least gives you a baseline defense against this state police.
Yeah.
Okay. What 486 actually does is two things. First one is that for those who wish to carry open and have a concealed carry permit, may do so without chance of repercussion from state police. That's our hope. Mm-hmm. Okay. Secondly, and most importantly, what it does is it establishes within the statute that our Second Amendment rights shall not be infringed. This statute complements Act 746 and provides secondary protections to our federal and state constitutional right to bear arms.
That's really good. It's really good. And I love that it addresses a specific problem with a specific state agency. And again, this bill becomes law without Governor Asa Hutchinson's signature. A lot of stuff to read into that if you want to take the time and do it.
It speaks volume.
Yes, it does. Jim Ennis from Greer's Ferry calling in, letting us know about this new law becoming in effect today. I appreciate it, sir. Thank you so much for coming on the program.
You bet, Paul, anytime. Thank you very much, sir.
Yes, sir. Folks, the Liberty Machine rolls on. We got to go to break. We'll be back in just a moment.